Hello and welcome to the 10th episode of Wahl on Law. My name is Jonas Wahl, and I am a pre-law student at the University of Delaware. On this podcast, we cover what's happening across the country in law and policy and how it affects your daily life. For the first time on Wahl on Law, we're joined by a special guest, Dr. Wayne Batchis, professor of political science and director of legal studies at the University of Delaware. He also holds a law degree from the University of Pennsylvania and a PhD in political science from Johns Hopkins University, and he is an expert in constitutional law, something that will be central to today's conversation. In this episode, we're diving into the Afroman trial, a case about a defamation lawsuit brought by police officers against a high-profile rap artist. Along the way, we'll explore questions about constitutional rights, police conduct, and somehow a slice of lemon cake. First, I want to provide a brief overview of the case. In August of 2022, 7 police officers executed a search warrant and raided the home of Afroman on suspicion of drug trafficking and kidnapping. However, they found no evidence and ultimately filed no charges. This raid drew attention for several details. At one point, an officer was captured on camera eyeing a slice of lemon pound cake from Afroman's kitchen. Officers were also seen disconnecting surveillance cameras and kicking down Afroman's door. Afroman later alleged that $400 in cash was taken during the raid. While he was not home at the time, his wife and children were present, and he claims they were left traumatized by the experience, as officers allegedly held his family at gunpoint. In response to the raid, Afroman used his own home surveillance footage to create an album titled Lemon Pound Cake. The album included songs like Will You Help Me Repair My Door, Why You Disconnecting My Video Camera, and The Police Raid, all directly referencing the incident. He also released music videos featuring footage from the raid, along with social media content and merchandise. When asked why he created the album, Afroman explained that he wanted to turn the situation into something productive, saying that he made a funny rap song about the officers to help pay for the damage and move forward. According to Afroman, the damage to his house totaled around $20,000. Following the release of the album, several of the officers involved filed a lawsuit against him, alleging invasion of privacy, emotional distress, defamation, and unauthorized use of their likeness. They argued that his content exposed them to public shaming and sought to have the videos taken down, along with nearly $4 million in damages. Ultimately, the jury ruled in favor of Afroman. So at this case's core, one question was raised. When does satire cross the line into defamation? And that's where this case really becomes less about one musician and more about the limits of free speech in America. Now, let's break down what actually happened during the trial. So before we get into the details of this case, this was a civil trial, not a criminal one. So for listeners who might not know, Dr. Batchis, what's the difference between a civil and a criminal case?
Thank you first for having me. This is a lot of fun. It's a really interesting case, right, and very colorful, like many First Amendment cases can be. So yeah, this was a civil trial, meaning this was a matter in which independent parties, right, have claims against one another. It's fundamentally different from a criminal case in that it's not the government that is bringing the charges, right? That is a prosecution, and one is accused of an offense to the broader public, right? That is the function of criminal law, and the penalties, right, in criminal law are can be quite severe. One can lose one's liberty, be locked up. One can even be subjected to the death penalty in many states. Civil law is really just about resolving a conflict between two independent parties, and one is harmed, and we as a society feel that that harmed party perhaps, right, should be compensated, that someone should pay the costs imposed, and civil law allows someone to take that question to court and present that their argument in front of a jury to resolve who should pay those costs. So this is about harm done and whether this is a harm that should receive compensation.
Got it. Thank you. So, in order to get this compensation, there were several claims brought against Afroman, including defamation and two types of invasion of privacy. So, focusing on defamation, what does defamation legally require?
So defamation has been kind of defined over time by the Supreme Court somewhat narrowly. It historically, is a falsehood that is spread uh, and has the effect of injuring one's reputation. So defamation comes in, it can be classified as either slander or libel. Libel is written, slander is spoken. Um, but either way, it's a harm, a sort of wrongful harm done to one's reputation through the spreading of a falsehood.
Got it. And so, as you said, one of the key requirements of defamation is that the statement has to be false. And in this case, one of the deputies testified that Afroman's lyrics implied that he slept with the deputy's wife and that it caused the deputy emotional harm. And when the deputy was asked if he knew Afroman's claim about his wife was true, the deputy said, "I don't know." So, how does that kind of uncertainty affect a defamation claim?
Well, I mean, first of all, there's the question of whether this was clearly parody, right? And the court has been absolutely clear that if something is a form of parody, it is protected speech. I mean, obviously, so much is said comedically, right? That is not intended to be taken seriously, that is not intended to present facts. I think here that's the obvious position that one might take is that this was parody.
Yeah, and I want to add that technically the deputy can't prove beyond a reasonable doubt that Afroman slept with his wife. So that uncertainty can also just lay a little bit more like uncertainty to the groundwork of defamation in the first place, which is surprising to me, but another interesting aspect of this case.
Yeah, I mean it's also a criticism of a public official, right? And that matters, and that has historically mattered to the court. Generally, it's much harder for a public official or public figure to sue for defamation successfully because of this tradition that we have in this country and that we take very seriously of being able to criticize the government or be able to criticize anyone who is in the public sphere because that is essential to our ability to discuss issues that matter to the public.
And I believe that police officers are covered under qualified immunity. Is that correct in terms of like their protections?
Um, so in terms of the police officers being sued, yes, right. So that would be the reverse of what we have here, right? We have the officers suing for defamation that they feel they've been harmed. In the reverse setting, typically that is right. It is a higher threshold, right? A higher burden to sue a police officer under the understanding that police officers have to have a little more leeway to make difficult decisions on the spot and therefore aren't to be held to the same levels of or same standards as the average person when it comes to for example negligence in performing their jobs.
Got it. And I know you talked about this a little bit earlier. So when we're talking about satire specifically, where is the line between protected speech and something that could be defamation?
So defamation, again, as the court has said, it has to be false. And with public figures and public officials, the person spreading the allegedly defamatory statement must have actual what the court has called actual malice, which means they have to be either aware that they are spreading a falsehood or reckless with regard to whether or not what they're sharing is false. And so that's a pretty high standard, right? You have to be either aware that that you're spreading a falsehood, or aware that it's pretty likely that this could be false, and you say it anyway. Which makes it, as I said, makes it pretty difficult for a public figure or a public official to sue successfully.
Got it. So, to give an example for our listeners, one of the claims that Afroman made was calling the officers white supremacists. So, would that statement qualify as defamation?
That's a tough one, right? I mean, because I think that would more likely fall into the category of opinion, rather than fact, right? And you have to argue that what is the definition of white supremacy, right?
Yeah.
It's really a hard thing to define. And part of, again, the tradition we have of being able to criticize public officials and public figures, is to say hyperbolic things, right, about them, that are a matter of opinion. So it is, that would be I think, a difficult thing, to present, to argue, is a clear falsehood in the way, misstating whether someone received a college degree or something that is a pure matter of fact, would be.
Yeah, definitely. And another example for our listeners, Afroman also called the officers like a bitch, but you can't. How do you prove that? There's not really any like set of guidelines to prove that in court. So that's why, while the officers may have felt like that harmed their reputation, you can't really prove that. It's like only go so
Yeah.
far.
And when you take on that role, right, as a public official, part of what the court has acknowledged in a number of cases is that you are implicitly accepting that you will be subject to criticism, and sometimes that criticism will come in a form that's pretty unpleasant, and but that goes along with the job, and that goes along with putting oneself out there in the public sphere.
So I want to shift a little bit to more about the case and like the videos presented. So does the First Amendment apply differently depending on the format? Like if it was like a written post or a video?
Generally, no. I mean, images and videos are protected as well. You might one of the first cases that might pop to mind is, there was a again, very controversial case that a lot of people did not like when they heard the facts. But for example, the court struck down a law that targeted what are called crush videos. Right, this is a kind of fetish, apparently. All right, in which live fuzzy animals are crushed under the heel of high heeled shoes, and this is, these were put on the internet, and this was made criminal. The depictions of violence against animal cruelty was criminalized, and the court struck that down, right? And again, no one, most people don't like these kinds of images. Certainly don't like cruelty to animals, um, but the depiction of such cruelty is still considered speech. And so in that, the case from maybe about 15 years ago, right, the court discussed, for example, documentary filmmakers. Right, there's a documentary filmmaker who was abroad and documenting dogfighting, right, where in a place where that was legal, right? Can such a documentary be made illegal in the United States simply because the act would be illegal in the United States? And the court is clear that that is something that is, it is certainly protected speech.
Got it. That was a great answer. And so in these videos that Afroman had, they were from his home surveillance camera, and the officers were arguing that Afroman improperly used their images in videos and merchandise. So first, one of their claims was unauthorized use of likeness. What does that claim actually entail?
Well, I mean, I think the use of likeness usually, can often go along with a critique, and so again, for a public figure, that goes with the territory. Now, there are, of course, some limits when it comes to commercial speech. The court has carved out a category of speech called commercial speech that does receive somewhat less protection. Um, and there's of course trademark law, right, which protects certain images as a kind of intellectual property. So there are some narrow exceptions, but generally, use of someone's likeness as a method of critique is quite common and protected, right? If you think about political cartoons, right, that are
Yeah,
one would find in a newspaper, that is a very well established way of criticizing politicians and other public figures.
definitely. And I also want to point out that Afroman wasn't just using these images to like sell anything. They were also part of his music and his satire. So by grouping it together as like creative expression and commentary, this is another reason why the court viewed it as this protected speech. As you know, if it was just to sell products, okay, maybe they'd have more of an argument. But it was tied together in more aspects than one, which I guess also really strengthened that argument.
Yeah, that's a great point, right? And so, and a lot of speech, right, that is classically protected speech is speech that is sold, right? That is, I mean, there's a famous case from the early '80s where Jerry Falwell, who is no longer with us, but who was a very well-known televangelist, and I believe his son is still quite active, but he was the creator of Liberty University. But he was criticized in Hustler magazine which is a pornographic magazine, a full page mock ad, right, in which he was talking about, and it was horrible for the guy. I mean, it was he was uh, supposedly doing an interview describing his first sexual experience, and he described it with his mother in an outhouse. Right? It was this awful, very humor and very bad taste. He sued, and he lost. Right? He lost because even though Hustler magazine is sold for profit. This was a classic protected speech, despite the agreement that it was in very bad taste.
Yeah, that's a great example to contrast to this case. So I know we've been focusing a lot on these First Amendment issues, but I want to look at the Fourth Amendment as well, as there was a search of Afroman's house. So first, for like searches with under warrants, what protections does the Fourth Amendment provide for these searches?
Well, the Fourth Amendment is quite clear, right? That there has to be a warrant, and in this case, there was, right? There was a warrant for this search. That means there was generally a sufficient cause, right? Probable cause to believe that there was good reason to search this property. Um, so that you need an independent judge to agree that a warrant is justified, and here that occurred. Although here the challenge is not to the search itself, right? It's the reverse, right? It's
Yeah,
because one can certainly, and I think this is implicit in much of his Afroman's music and lyrics, right? Is that this was excessive, right? That the way they went about this search was went too far, and that is, of course, how we hold our officials accountable, right? Through
Yeah.
free speech, through criticisms of whether or not the way in which the police are doing their job is proportional.
Definitely. And I know you mentioned that one of his concerns was the damage. So is there like a limit for how much force is considered reasonable when executing a search warrant, or is it sort of like up to an officer's discretion?
There certainly are limits. I mean, I actually that is a little bit outside of my expertise. I don't do criminal procedure. I do focus a lot on the First Amendment. But absolutely, are there standards for proportionality? Yes, and it's very context dependent. And there's a large body of precedent out there determining the boundaries of when it comes to searches and seizures.
I know we mentioned this earlier, but if Afroman wanted to sue the police department for damages, he probably could do that. But in terms of if it would win or not, it'd be pretty hard considering, again, the immunity that some officers do have for like warrants. And so yeah, it is his right to sue for damages if he wants to, but it could be pretty hard to ever see money for that claim.
That is true. That is a high bar, right? Because of course, I mean, if procedures were followed, and it sounds like they were under these
Yes,
circumstances, right, and an independent judge determined that this search was appropriate, then yeah, I think that's right. But we have other methods of seeking accountability in a democracy, right? And that is, the voting booth, and making it clear that we think, perhaps powers are being abused or are being taken too far, and that is our right to make that to voice our concerns if we feel that there isn't proportionality.
definitely. And I know that you said like elected officials, even though officers aren't elected, they still do have to be held to standards. Given that they interact with the public a lot. Yeah, so it's important to note that we do have these methods to keep officers in check and everybody else in check, especially today when it's getting more hostile every day. Um, so I have one final question for you here. So after the trial, Afroman's content actually became even more popular. So can lawsuits like these sometimes backfire and instead bring more visibility to speech someone's trying to challenge?
I mean, without a doubt, right? Without a doubt, right? And I think that's you have to certainly admire the way Afroman took this opportunity, right, um, to make a really important point, right? And so yes, I think and I did do a little bit of research for preparing for this podcast, but I can't say I know everything about this case. But certainly some of the clips that one sees just from the news coverage that's received didn't make the police look terribly good, right? So I mean this was um, I think a very effective use of an artist's voice to make a larger point. And I think this the lawsuit um, did not help from the perspective of the police. I think if anything, you're correct. It did shine an even brighter light on what occurred.
Definitely. And the first time I saw this trial was actually on Instagram through a clip. I don't think I would have ever seen it if it wasn't through for social media. And another recent example is the Johnny Depp and Amber Heard trial that's happened recently. It got publicized everywhere. I think everybody was talking about it. And if Amber Heard decides to go a different route, maybe it wouldn't have been as public. So, a little bit of backfire there too. Um, so that concludes the questions I have for you. Thank you for joining me today and breaking down the Afroman trial. This was a great conversation. I think really added a lot of valuable insights. Um, yeah, if the listeners out here enjoyed this episode, make sure to follow or subscribe to Wahl on Law so you don't miss any future episodes. And you can also sign up for our email list at wahlonlaw.com to get notified whenever a new episode drops. So thank you again, Dr. Batchis, for coming on this podcast. It's been great. And I will see you guys next time on Wahl on Law.
Thanks so much for having me.